morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases up for argument today. The other cases have been submitted. The first case up for argument is case number C-240535, State of Ohio versus Benjamin Riffey. Ms. Gooder for the appellant. All right. Did I say the last name correctly? Riffey? Okay. The second case is C-240598, State of Ohio versus Londell Swanigan.
Mark Peters for the appellant. Working the case, operating under a limited legal license under the supervision of Attorney Laura Peters.
Welcome. All right.
And Ron Spooner for the state board to proceed.
Thank you. And the final case up for argument is case number C-240060, Ditech Financial LLC versus Kalimba Balamunkwe. I hope I said the name right. You can correct me.
You did, Your Honor. George Parker on behalf of Mr. Balamunkwe.
Good morning.
Good morning, Your Honor. Jack Moran here on behalf of URES LLC, doing business as Shell Point Financial, which is the substitute plaintiff, and thus the appellant.
All right, great. Thank you very much. All right, so we're going to start with the Riffey case. Ms. Scudder, would you like to reserve some rebuttal time?
Yes, can I reserve 3 minutes?
3 minutes. Let me set that up. I got a fancy timer up here. Hopefully the lights are working on the podium. I'll hit the yellow light when you have about a minute left of your initial time. So whenever you're ready.
All right, good morning, Your Honors, opposing counsel. May it please the court. The state raised 2 assignments of error in this case. The first challenging the trial court's decision to hold the weapons while intoxicated statute unconstitutional as applied to Mr. Riffey under the U.S. Constitution. The second assignment error in that same statute, but however, the court found it facially unconstitutional under the Ohio Constitution. And there's 3 main reasons that the trial court erred in this case. First, it was slaying a straw man argument. It was applying the law to facts that were not present here. Second, it was searching for a historical twin rather than an analog, as required under Bruin and Rahimi. And third, it was conflating facial and as-applied challenges under the Ohio constitutional analysis. And so starting with the straw man argument, the trial court here was finding constitutional violations to a hypothetical situation. First, if you look at page 6 of its decision, footnote 4, it talked about how the record was devoid of facts that indicated the gun was not carried or not used for self-defense, and that it was the state's burden to prove those things. First, I would emphasize that it's not the burden of the state at a motion to dismiss setting to prove that the defendant was not acting in self-defense. That's something for the trial court. They need to put facts forward that prove that those are the factual scenario in an as-applied challenge. It will be the state's burden to provide the historical record under Bruin and Rahimi, but it's not its job to provide the facts as an as-applied challenge that the defendant was acting in self-defense.
Was this a violation of Criminal Rule 12C then, for the judge to look at issues that were capable of determination at trial? I mean, it sounds like she kind of decided the case pre-trial.
I think so. I think the judge decided that Mr. Riffey was indeed acting in self-defense, mixing up the idea that there are factual scenarios that will have to be proved at trial and what the state's actual burden is at a motion to dismiss setting, which is, under Rahimi and Bruin, just the historical record.
So what can we look at fact-wise in deciding this motion, this as-applied challenge?
Yeah, so the stipulated facts were set forth, and then also Mr. Riffey also set forth some facts in his motion to dismiss. What those were that the police dispatched to the vicinity of Mr. Riffey's home based on a shot spotter and a 911 call that there was a shot from a balcony, a second-floor balcony. And in his motion to dismiss, he then elaborates on that fact and says the police showed up, found him near his second-floor balcony. The police shined a light, he came out, dropped the gun over the railing to the police. And so I think there is enough to say that he was operating, he was using the firearm, that was the shots, but if this court doesn't believe that, and it's that it was just carrying, I think the analysis is the same.
So in an as-applied challenge, we can take into account facts that are alleged in the brief of the defendant?
I would say that the court can. If the defendant's admitting to facts in his motion, I would say that the court can consider those, as well as the stipulated facts that were set forth.
And what were his additional facts? He was on the balcony?
So that when the police arrived, he was in the window of his second floor balcony, and he came out and then relinquished the firearm over the balcony. I think there's enough, if there's a 911 call that the shot was fired from a second floor balcony in that vicinity, police show up to that vicinity, to the second floor balcony, and he's the one that comes out with a firearm and drops it, that would be enough to at least connect a motion to dismiss hearing that he was using the gun, not just carrying it.
But he was only charged with carrying it, right, in the complaint? Because
would
I
have
thought
to-
use was crossed out and carry was put in.
So that, I would say, still the facts are set forth in the motion to dismiss, but if it is carrying, I think the analysis is the same. And that, I'll emphasize the other operative facts here are that there are no facts as to Mr. Rifey being alone. That was never set forth at a motion to dismiss hearing or in the stipulated facts. There was never mere possession of the firearm. It wasn't that he just had it around him. It was that he was at the very least carrying it. He was handling the firearm. And then also there were no facts as to him acting in self-defense. There is nothing put forward that he was using or carrying it in self-defense, and that's important. While self-defense plays a part in the Second Amendment analysis, absolutely, that doesn't relieve Mr. Rifey of his burden to set forth facts that he was indeed using that firearm or carrying that firearm in self-defense.
Counsel, what's the historical analog that would prohibit Mr. Rifey from carrying a gun in his own house?
So I think that the state set forth quite a couple of historical analogs, one being from 1655, the Virginia law that imposed a fine on shooting while drinking. There was another one from 1771, both pre-ratification of the Constitution, that also prohibited firing a gun around New Year's Eve, and then a New Jersey one in 1746 that there was a regulation that allowed soldiers to be disarmed when they appeared intoxicated.
Do any of those statutes deal with possession of a gun inside the home?
None of them distinguish about public or private use, and I think that's important here. They don't limit it to public use only, and I would argue that the 1771 New York law that prohibited everyone, not just those intoxicated, everyone from firing a gun during that 3-day New Year's Eve period, a lot of those individuals would have been at home. They would have been celebrating with friends and family at home, and so I don't think we have to find a historical twin that says you can't carry a firearm in the home while intoxicated. We need to find one that says, we regulate people that are dangerous, which are the currently intoxicated, because they can't safely use a firearm. And I think we've done that.
We're looking at, we have how and why. The why is because people that are drunk are dangerous to others, right?
Correct.
So if they're in their own home, especially alone, why does that, how can that be a problem?
Well, first I would say we don't have any fact that he was alone in his
Would it
home.
matter?
Well, I would say, too, I think it doesn't matter in this case for an as-applied challenge if we don't have facts that he's alone. But I think in State v. Weber, Justice DeWine in his concurring opinion kind of talked about this. There's a lot of instances where people are in their home and there's people in that home, spouses, children, friends they invite over. And in this case, an apartment building where someone's very in close quarters, while they're in home, they could still be a danger to someone else. Shooting a gun in their house could hit someone else.
Do we know this was an apartment building?
We do in the stipulated facts, I believe it said apartment
Okay,
building.
so it wasn't a house by itself.
I'm sorry, in his home is what it said in the stipulated facts, and then in his motion, he recognized it was an apartment building.
But even if he was alone, he's running around in his house by himself intoxicated, he could injure himself, right?
Correct, and I
And
think
then the
that
government's going to have to come in and clean that up.
I would completely agree, Your Honor, and I would say also the Second Amendment is to defend, persons and property. I think there's also a potential damage to property or himself. It's not just that he's in his house. The analysis is he a danger to others and to property, and I would say he is.
What about this idea that inside the home is at the very core of the Second Amendment protections? Don't we need something to provide a historical analog that talks about the home specifically?
I don't think it needs to talk about the home specifically. I think absolutely in the Second Amendment analysis and the fact that it's in the home, the self-defense, the weight it's given is going to be more acute because we are in a home setting. However, I think there's a difference between a factual scenario of someone asserting an as-applied challenge that they used or carried their firearm in the home and just the general consideration self-defense plays in a Second Amendment analysis. And I think to say otherwise would say that any firearm regulation would be unconstitutional because it's inherently going to limit someone's use or possession or ownership of the gun. That's inherent that a firearm regulation is going to limit someone's ability to act in self-defense. There's no firearm regulation that wouldn't do that.
And this law doesn't prohibit somebody who is intoxicated from possessing a firearm
Correct.
in the home,
Correct.
as long as they don't pick it up, basically.
Exactly, and I think that's important. That's what it is regulating. It's regulating not ownership. You can own a gun when you're intoxicated. You can possess that gun when you're intoxicated. It's not like Heller where it made it that you had to have an inoperable gun. You can have an operable gun in your home when you're intoxicated. I would argue you can even be drinking one beer and have gun, as long as you're not intoxicated. That's the threshold. And so the burden in this case is only limited to when you're intoxicated. That's a self-imposed disability. Mr. Rifey can elect to not be intoxicated. It's his choice to become intoxicated, and once that happens, now he can't accurately defend himself in self-defense. And so I think going to this court's argument in State v. Thacker, there were two kind of categorical bans that it said the state could show, kind of two types of ways the state could show that it was satisfying Rahimi and Bruin. The first was to point to a similar historical disarming statute. I think we've done that here. With those three pre-ratification statutes, I think those are very similar in the why, in that currently intoxicated people have limited facilities and cannot discharge or handle their firearms safely, and the how. This isn't like Thacker, where it was a nonviolent juvenile adjudication and an indefinite limitation on gun rights. This is just at the time that you are currently intoxicated, so it's a very limited window. Similarly, this isn't like State v. Brown, where the person was under indictment. They could be disarmed for as long as they're under indictment, which could take years, as we know, in the criminal proceedings. This is a very, very small window, and so it's very different in duration than other statutes that this court has found unconstitutional. I think this statute can also fall into this nation's longstanding practice of allowing legislators to disarm those they determine to be dangerous. I think that it can fall into both categories under State v. Thacker. I'm moving to the Ohio Constitution arguments.
Can I revisit this idea that the legislature can disarm those that it considers dangerous?
Yeah.
Is it valid to depend on laws that were designed to disarm people based on protected classifications like race? Specifically, blacks and Native Americans were considered to be dangerous under these statutes and were disarmed. Should we rely on these same statutes now?
Specific to the three I cited, or just in general? Should we
Just in
rely?
general.
I think that we shouldn't rely. I think the why is different in those cases. That's choosing why based off the legislator presuming a certain type of people, a certain race of people were dangerous, which I think would have its own equal protection issues. But aside from that, I think that this is different because it's applying to all people evenly. And it's just saying that people that are intoxicated, that small class of people that have chosen to be that way, are the reason that this is prohibited and historically has been similar to historical laws. And I'm wrapping up. I see my time's out. I would just ask that this court affirm both assignments of error and find the weapons while intoxicated statute constitutional under the Ohio and federal constitution. Thank you.
Thank you.
Good morning, Your Honors.
Or-
Good morning, opposing counsel. Sarah Nelson again on behalf of Mr. Riffey. I'm going to go off script and try and address the key questions that were raised, something I don't usually do, but I think it's important today because I want to start with the factual record in this case. The motions motion to dismiss and motion in response were both filed before the stipulation of facts, which I think is important for the record, because when we go into the motion to dismiss hearing, the parties are arguing their case based on the stipulated facts. So I think the facts that were argued in the motion become irrelevant at that point. We are now agreeing what the universe of facts are when we argue our case to the court at the motion to dismiss hearing.
So we don't consider what's in your motion?
I don't think that that's appropriate based on the stipulations.
Okay,
Um,
that's what I
however-
was wondering.
Yeah, and that's how I read the parties' arguments. I know that the court gave some pushback when there was representations outside of that stipulation in the record. And saying, hey, you guys stipulated to facts, so that's what I'm operating under. So I think when we're talking about whether the trial court erred, we have to focus on what the trial court considered, which is the stipulated facts.
But can I ask you, though, about Criminal Rule 12C? My understanding is the motion to dismiss must be capable of determination without the trial of the general issue.
Yes.
And what it seemed like from reading the judge's opinion is that she basically said the state can't prove their case.
There was a footnote that did allude to the fact that the state didn't put on any evidence that would have met their burden disproving it. I don't think that that's a fair characterization, however, of what she did in this case. The trial court judge really just honed in on the self-defense being the essence of Second Amendment protections. The person is most acute in the home, which is what we're dealing with here.
But here's where I'm getting caught up. So, first of all, there's nothing in the stipulation showing that Mr. Riffey was carrying the gun for self-defense purposes. And also, if he had not made the choice to consume alcohol or to be intoxicated, we wouldn't be here with this. So isn't this about his choice to do that?
His
Here?
choice to be intoxicated.
Yes.
I'm not sure I understand the court's question, sorry.
Okay, so I understand what you're saying about how the need for self-defense is paramount in the home. I understand
Part
that.
of the Second Amendment, yeah.
Yes, but when somebody makes the choice to be in a state where them carrying a gun becomes more and more dangerous, how are we to look at that?
Yes, so when we look at the historical sources cited by the state in this case, the distinguishing factor that makes the historical sources dissimilar is the danger to the public, which is important. It goes back to the factual record about whether or not Mr. Riffey was alone. There's no indication that he was around other people. It doesn't clearly spell out that he was alone, but the only people that are talked about in the stipulated facts are Mr. Riffey and the fact that he was encountering with the police.
Isn't that a problem, though, that the stipulation doesn't stipulate that he was alone in his home?
I don't think so. I don't think that destroys our argument about him not causing danger to others, because there's no information about other people contemplated in this scenario.
So are you saying that it's not necessarily the being drunk and carrying a gun in the house that's the problem, or it's only if you're alone then it's an issue?
Being alone makes this case dissimilar to what history tells us can be regulated.
So if he had people, so your argument is if there were other people in the home, then it would be constitutional as applied.
If there were other people in the home, the state could, yes, constitutionally say that you're carrying a firearm in this instance because of the danger you pose to other people would be valid, I
So
think.
your whole argument hinges on him being alone in the house?
Yes.
Okay.
I think
How do you respond to the state saying, well, he could hurt himself, if he's in an apartment, the gun could discharge and hit a neighbor?
I don't think that nuance is contemplated by the historical record. Danger to self is not as important to the law as the actual activities and the public aspect of what the historical record shows. So for instance, the state cites to shooting while drunk, that is an action that's being targeted by the drunk while using firearms, actual shooting, which isn't contemplated in this case. We just have mere possession, so less danger involved there. The other one that stands out is about shooting during New Year's Eve time, definitely contemplating crowds, other people, and not necessarily harm to self. I'm not aware of any statute that necessarily criminalizes harm having firearms and causing
What
harm.
about the accidental discharge situation?
Is
Like, what the state was saying that he was in
Oh.
an apartment and he could accidentally discharge the gun and it could hit somebody in a neighboring apartment.
Sure, different set of facts, though. We don't have facts in this case that reflect that he actually used the firearm. The shots fired were the pretext for why police were
No,
at the
it's
scene.
about carrying. If you're
Yes.
carrying, the danger to, just by being drunk and carrying a firearm is dangerous to other people in the apartment building.
Well, the statute contemplates two different things, use or carrying.
And he was charged with carrying.
Right, and I think that's a separate situation when it comes to harm. If there is a use situation, then that would be covered, but the danger of just having a firearm, I think, is less supported by the historical record that the state puts forward.
Well, and I don't think that, looking at the stipulation, I don't think that that only encompasses harm to self. I mean, the police responded to a dispatch and a 911 call that there was a shot fired from a balcony. And so he wasn't totally by himself during this entire incident because the police were there.
The police responded to the shot spotter and a 911 call regarding shots.
Yes.
But we don't know who the 911 caller is, and shot spotter gives a range.
I understand that,
So-
but the police were at his home, and he appeared to be intoxicated, and he relinquished his firearm. So they were there when he was intoxicated and carrying a gun.
I understand the nuance you're pointing out, but I don't think that the harm to police is necessarily what the statute contemplates or the historical record contemplates. But that is an interesting point, but I think the history of this type of regulation goes more to like public crowds and other people, not necessarily using, or it's circumstantial in this case. He just had a gun and police showed up. It's not necessarily they showed up specifically for him. That's not what's in the record. So anybody who had a gun in that moment who had been drinking in their home, would be subject to this law, and I don't think that's what the law contemplates or the history of this law contemplates.
So I guess I was confused on the record. He wasn't charged with, the police didn't show up and say, hey, do you have a gun in here? And then he got his gun and gave it to them, and then they charged him with carrying. That's not what happened.
Well, based on the stipulation, they arrived, they encountered him in his home, and then he relinquished control.
Okay, so we don't know.
It's sufficiently vague.
Where he
I
was
think.
carrying a gun.
Exactly, and that's, I believe, the universe of facts that we go with here. When we're not talking about like causing danger to others, that's, whose fault is that? I'm not sure, but the trial court thought these facts were sufficient enough for her to make an as-applied determination that just by being drunk in your home and not necessarily causing harm to other people based on this factual record, then the Second Amendment doesn't, the Second Amendment protects that conduct.
Are we allowed to look at the other charge when considering this? Because that did allege that Mr. Riffey shot his gun.
Yes, I believe that was a completely separate incident, however. I don't think that they happened at the same time, but I don't mean to speak out of turn.
I think you're right. I re-looked at that the other day. I thought they, because they were charged in the same case.
They were charged in the same case.
But they were two different dates.
I do believe they
Yeah.
were completely separate
Okay.
incidents, so I don't think that that would be appropriate. But if there was a companion charge that did contemplate present use, then maybe we'd have a completely different case and I'd be appellant. But that's not where we're at today. Okay. Excuse me one second.
Does the state have any interest in preventing individuals who are intoxicated from harming themselves? So in other words, he's bouncing around the apartment intoxicated and he blows his head off. Does the state have an interest in making sure that doesn't happen so they don't have to expend resources dealing with that?
Probably a general interest, but not one that's supported by our nation's history and tradition, at least based on the historical record that was provided to the trial court.
The restriction on dangerousness that has been adopted historically is not applicable?
I struggle with the state equating intoxication and dangerousness in this case.
Well, intoxication, handling a firearm equals dangerousness.
Yes, that's what the state argues, but I think that we have to add the other people component to make the intoxication truly a dangerous activity. And second, when we think about dangerousness in terms of alcohol, use, I think the precedent is really about chronic alcoholism or drug abuse, that type of dangerousness, not necessarily the one-off, I drank a couple of beers and now I'm overly intoxicated, because, and then a few hours later, I will be less dangerous. That's kind of the world that we're living in this case, is that he's not a chronic alcoholic based on this record, which would create a disability. He's not under a disability. So I don't think that he is the type of dangerous person as contemplated by the nation's history and tradition.
So there has to be people around, is what you're saying?
I think that that's significant. I think that was also significant in Weber.
It was, but I guess what I'm confused about is when looking at an as-applied challenge and going back to the facts, the parties stipulated, the stipulations are, there's no stipulation about who's in the house, or if he's alone, he's not alone. So you're saying we just assume that he's alone? Why can't we just assume that he wasn't alone?
I think that we presume the regularity of proceedings, and that's what the trial court found in this case, and we don't have anything to say that that factual finding was not credibly supported.
But I think that's key, right? That's key to your argument. To me, it seems like it should have been included. I mean, I know you weren't the lawyer below, but it should have been included in the stipulations.
Sure, but then I guess the question is who has to include that stipulation, because who has to include that? Because both parties agreed to this. So that
I would say the
think-
person doing the as-applied the side doing the as-applied challenge would want to include that in the stipulations if their entire argument rests on the fact that he's alone.
Yes, so I'm using the word alone, that alone is not in here, but what this shows is that the police only encountered Mr. Riffey. They didn't encounter Mr. Riffey and other people in his home, and that, I think, is a fact that the state would have needed to negotiate for if they wanted it to be in this stipulation. So because it's not in here, I think we defer to what the trial court found was that he wasn't with other people to cause harm to other people. There is some ambiguity in this, but when I read this, I just see Mr. Riffey. I don't see the stipulation contemplating other people. And if the whole premise of, being able to regulate intoxicated people with firearms, the history and tradition shows other people contemplated, then that's something that, the state, who has the burden of producing the historical record, would have needed to put in this.
Yeah, but who has the burden of producing the facts for the as-applied challenge?
I believe it's on the defendant, but again, I don't think that it's fair to read this as saying there were other people present other than the police.
Well, I don't think you can read it anyway.
Well, then we go back to what the trial court did in this case and found it in the defendant's favor and said, if you're not causing harm to other people or there's no other people contemplated.
So if it's ambiguous in facts, we defer to the trial court?
I believe so. The de novo review applies to I don't know.
But the trial court's
Yeah.
factual findings have to be based on something.
Yes, and they are based on this stipulation, which doesn't contemplate other people. I appreciate your point. I'm not trying to be combative.
No, I know
Yeah.
you're not. I'm just trying to figure out. I feel
What we
like
do
there's
with
a
this.
hole in there's something lacking in these stipulations, and I'm trying to figure out what we do with it.
So the way that the as-applied challenge got narrowed in this case, I believe, is, disarming an intoxicated person from carrying a firearm in their own home. And I think that this stipulation doesn't contemplate other people, and that was an important nuance in this case.
Okay.
I'm going to stand on.
Yeah, no.
I know that the state didn't have, I'm not sure if the state had an opportunity to really get into the second assignment of error in the Ohio Constitution, so I will respectfully submit on that. I would just like to point out that this case can be resolved on the as-applied challenge, so if there is some hesitancy to consider the facial aspect of the Ohio Constitution, it need not, and that precedent can live in uni court until the Ohio Supreme Court tells us what kind of analysis they want. I do think it's interesting that the trial court did look for Ohio-specific rules to basically apply Bruin in Ohio, but Ohio-specific sources. That is an interesting nuance, but again, one that the court doesn't need to reach if it's satisfied with the as-applied decision. And I'll submit on my brief for the remainder of my argument.
All right.
Thank you.
Perfect timing. We're almost out of time.
Your yellow light works, so.
Scudder, you have 3 minutes for rebuttal.
Thank you, Your Honor. I'll start with the Ohio Constitution since that was what was last spoken about. The trial court's holding that it was facially unconstitutional under the Ohio Constitution has to be reached by this court because that decision is saying it's not as applied to Mr. Rife or people in Mr. Rife's situation. It's saying that that statute under the Ohio Constitution applied to everyone that comes before that court, that's an unconstitutional statute. So that needs to be reached by this court and can't be just reached on the first assignment error. It needs to evaluate under the second assignment error. And I would say that the court has a few options. I agree with opposing counsel that the trial court narrowed its analysis very oddly. It said it had to be a historical regulation in effect in Ohio, saying that.
Before you get into that, though, the Supreme Court of Ohio hasn't adopted the Bruin framework yet,
Correct.
right?
Yes.
So do we even go there? I mean, I feel like we're all anticipating that they're going to.
Yes.
But they haven't yet.
Correct. And I think that this court has kind of three options. I think you could apply Bruin if you wanted. I think that you could also decline to address whether the Ohio Constitution will go in lockstep with the federal, because that wasn't really briefed below if there is a separate standard or what that analysis looks like, and just rule on the fact that how the trial court here applied Bruin was improper. So, and then the third option would be to develop its own standard. The Ohio Supreme Court hasn't weighed in on this. If this court believes that there is a certain standard that should be used under the Ohio Constitution, I think it can do that. So I think it kind of has three ways of going about that. I would also emphasize that when it does that, it would not be limited to the Ohio historical record. It can take into account the national historical record, and the 5th District did that in Jenkins, and then the dissent and also from the 5th District in Skaggs. And so it can take into account all those other, states around it and those pre-ratification historical record the state's already pointed to. It can also look before 1802. The trial court limited finding a historical twin, I would argue, to the period of 1802 to 1851. And that's also incorrect. You can consider regulations that occurred before 1802. And again, the state provided those. So I think it was narrow in that regard. And then,
Can you address the issue of the vagueness of the stipulations, and how do we analyze whether he was alone or not?
I think you have to read the stipulated facts as they are, and it does not say he was alone, and I think it is the defendant's burden to put forth facts that would support his as-applied challenge. It is not the state that brought this motion to dismiss, it's the defendant. If he believed that was an important fact to his as-applied challenge, it should have been in there. And that's missing, as well as any facts supporting that this was used or carried in self-defense. And so I think the vagueness weighs in favor of the state here. The state didn't put in facts that weren't going to help it, and the defendant had its job to do that, and the state then needed to win at the end of the day under a Bruin analysis. But it's his burden up front to prove the motion to dismiss and establish the facts. And I think the trial court relied, and if I may briefly wrap up, I see my time's out. The trial court relied on facts that were not in that stipulated entry. And I think that's a really important and necessary component to this court's analysis. I would ask that you reverse and remand the trial court's decision on both assignments of error. Thank you.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day. Okay, the next case set for argument is State of Ohio versus Swanigan. Ms. Pace, would you like to reserve some rebuttal time?
I'd like to reserve 5 minutes, Your Honor.
5 minutes, okay. Whenever you're ready.
May it please the court. My name is Brooklyn Pace, and I am operating under a limited legal license under the supervision of attorney Laura Peters. This case is about what the statute says, and most importantly, it's about what the statute doesn't say. This appeal presents a straightforward question of statutory interpretation. What does Revised Code 2945.38 actually say about how long someone like Mr. Swanigan can be held in a treatment facility for competency restoration? The answer comes from the text of the statute itself. It's 6 months, and it's 6 months only. And yet, Mr. Swanigan was ordered by the trial court to undergo a second 6-month period of competency restoration after being found incompetent from a community control violation. He had already undergone 171 days of restoration treatment in connection with that original offense, a third-degree felony, which falls under the 6-month maximum treatment allocation. The trial court found and the state argued that the 6-month clock resets automatically when a new finding of incompetency occurs. But the statute says otherwise. Revised Code 2945.38 is not ambiguous. It explicitly sets maximum restoration periods and uses definitive language. Section 2945.38C2 of the statute says, and I quote, "No defendant shall be required to undergo treatment for longer than 6 months if the most serious offense which with the defendant is charged is a felony other than a felony described in Division C1."
Ms. Pace, how do you distinguish this case from State v. Henderson?
Your Honor, the court should have followed the analysis in Hudkins and not in Henderson. The court in Henderson misapplied the statute 2945.37, and then they also incorrectly did not cite any authority when they claimed that the clock could reset. Alternatively, in Hudkins, where the facts are more analogous, they did cite where they were getting this from, and therefore the court should have followed what they did in Hudkins. And I'll talk a little bit about that. In Hudkins, the 12th District Court of Appeals had a pretty similar scenario. The defendant had been restored once, but then later found incompetent again, and when the trial court ordered another 6-month period, the appellate court reversed. The court in Hudkins correctly therefore held that nothing in the language of RC 2945.38 suggests that the clock restarts after an intervening restoration. The term maximum means maximum, and the statute uses it repeatedly, 10 times in fact, with phrases such as maximum period permitted, maximum time for treatment, and maximum time for continuing evaluation and treatment.
Does it matter here that this is a community control violation?
No, Your Honor, it does not matter. As Mr. Swanigan was found incompetent, no proceedings can move forward at all, even though this was merely a community control violation.
So this statute, it seems like both sides seem to agree that, or they don't, nobody argues that this doesn't apply to community control violations, right?
Correct.
Everybody's
We are
in
not arguing that,
agreement
Your Honor.
that this applies. And so what you're saying is if somebody, like in this situation, he was found incompetent before he pled guilty, right?
Correct.
And he was held for 5 months or so.
171 days. yes,
And
Your Honor.
then pled guilty, was sentenced to community control.
For 3
then
years.
if there's a community control violation, this clock continues on. It doesn't reset for the community control piece of it.
Correct. Mr. Swanigan, when the examiner found that he had been in treatment for 171 days, so about 5.5 months, there was only about 2 weeks, a little less than, remaining of that 6 months. And so the remedy should have been to dismiss that community control violation, and if Mr. Swanigan was still incompetent, then, refer him to probate or civil court.
So what the state could do, so the remedy that you're asking for is for us to order the trial court to dismiss the community control violation.
Yes, Your Honor.
Could the state, I think the statute permits the state to just go ahead and refile again, right?
It's incorrect that the proper remedy would not be to dismiss and refile the exact same charges simply to get around this clock. That would not be the proper course of justice for Mr. Swanigan.
If he became competent in the interim, and we rule on this case and say we agree with you and the court dismisses it, you're saying the state couldn't just refile the community control violation now that he's competent?
I do not believe that the state can dismiss and refile the exact same charges simply to try and restart a 6-month clock. No, Your Honor.
Well, not to restart the 6-month clock. I think it would be to be able to prosecute him on the community control violation. So if he becomes competent,
That charge was picked up in Butler County, so yes, Butler County could pursue the community control violation there.
well, he got charges in Butler County, but violated community control here, correct?
Correct, sorry, yes,
Yeah.
I misspoke, yes. He was under community control for the robbery for the 3 years, and then he picked up the community control violation was in Butler County.
Okay.
Going back, in contrast, State versus Henderson, which is from the 5th District, involved a new indictment, a new case number, and relied on RC 2945.39.
If I'm remembering correctly, that new indictment was based on the same conduct as the original indictment, correct?
In State versus Henderson?
Yes.
Yes.
Okay, so the charges, or the indictment was dismissed and then refiled? It sounded like the charges weren't dismissed until after the state re-indicted him.
To be honest, I'm not recalling exactly
Okay.
which order those events occurred, Your Honor.
Okay, but did Henderson, and I don't remember this, did Henderson, anything in that opinion suggest that the state re-indicted him for the purpose of restarting the clock?
I know in State versus Henderson, I don't believe they did it purely just to restart the clock, but again, in this one, it was a new indictment number and it had a new case number, and so we're not arguing that, and with that set of facts, that is different from our set of facts, which is that you could not simply just dismiss and then refile the charges in order to have more time. In State versus Henderson, they relied on RC 2945.39, which applies only to serious felonies, most commonly first and second degree felonies. And not only is that statute not applicable here, as it does not apply to third degree felonies like Mr. Swanigan's, but that statute was misapplied in Henderson, and yet the trial court in Henderson allowed it to control, and we believe that that is in error. Mr. Swanigan was found incompetent in November of 2022, restored after 171 days, pled guilty in May of 2023, and was placed on community control for 3 years. In July of 2024, Mr. Swanigan violated his community control. Subsequently, he was again found incompetent in October of 2024, but that charge was never dismissed and there was no new indictment. The community control violation is a continuation of events from the initial charge, not a new case. There is no legal event that justifies a reset. If the courts can restart the clock repeatedly, the 6-month cap becomes entirely meaningless. It creates a risk of indefinite civil confinement under the guise of treatment. This is especially concerning as defendants could get caught in an endless loop of new findings of incompetency and referrals to treatment that results in the defendants being held for longer than they would have if they had just been charged and found guilty of the original charges. That's not just inefficient, it's unconstitutional as it deprives defendants of their liberty. It offends the basic principles of due process and it violates the legislative purpose behind RC 2945.38C2 to limit the state's authority to detain people indefinitely in the name of restoration. The statute is clear. The cap is 6 months for offenses such as the one Mr. Swanigan is charged with. That time was nearly exhausted during the first period of restoration, and it was found unlikely by the examiner that he could be restored to competency in time at his September 20th competency evaluation. The court must interpret the statute as written, not as imagined. Unless the court has any further questions, we ask this court to reverse the trial court's order and remand for further proceedings with instructions to dismiss the community control violation. Thank you.
Thank you.
May it please the court and counsel, 2 points. The first is to be made with the case of State versus, it would be Henderson, the 5th Appellate District. And the very last paragraph on page 28 indicates that if the charge is dismissed, as it could have been in Hudgens, nothing barred the state from recharging Hudgens. So I believe that in the instance if this court would find that there was a statutory violation and that the trial court should not have credited that 271 days of restorative treatment, then the state could bring the charges, the community control charges anew.
I think the statute says that too, right?
Yeah, it's in the statute. and-
Dismissal is not a bar to further prosecution based on the same conduct.
Right, and that's been mentioned in Hudkins in the very last sentence. Another couple other things I would point out is when you're assessing competency, you're assessing the defendant's state of mind at the time of the proceedings, again, not at the time of trial. And when we look at the facts of this case, I think they're more in line with the Henderson case, because what happened in Henderson is there was a dismissal and a reindictment. Here, what happened, the intervening time was you had the defendant plead guilty to a robbery offense and committed to Summit in September, and then determined to be incompetent in November of 2022, then found competent in April of 2023. Then the defendant entered a plea of not guilty by reason of insanity in May. Then the court ordered another competency evaluation in May of 2025. The defendant withdrew the not guilty by reason of insanity plea also later in May 2025. And then the defendant was sentenced to 36 months. I should be saying 23. But what bottom line was, there was a couple of years before the defendant then was, I think about 2 years went by when the defendant committed the community control violation. And I know when there is a community control violation, it's a separate charge, but it's not under a new indictment number. And to me, it's more in line with Henderson and not Hudkins, because you had that 2-year intervening period. And so when the defendant was up for the community control violation, it was important to assess whether or not the defendant was competent to proceed under that community control violation. So it only makes sense then that you would want to give the defendant the opportunity to be restored to competency anew. And
So
just start
I think
that
it's an
anew.
interesting argument. So you're saying that by virtue of this being a community control violation,
Right.
basically
To
being
be
considered to be kind of a separate case,
Yes.
that's what starts this clock anew.
Yes.
Not the fact, you're not arguing that every time a defendant becomes competent, the clock resets.
No, that's not the
It's,
law.
it's, right. It's by virtue of this being a community control violation is what resets the clock.
Right, so if the defendant were compliant and followed community control as ordered by the court, then this would never be an issue. So it's not going to recycle itself and repeat itself for somebody that's constantly having to be in restoration for 6 months and then.
That's not the way I read your brief, though. I mean, I read your brief as saying that if somebody is committed for competency restoration, and then there's an intervening period of competency, and then the person is then declared incompetent, that restarts the clock. I didn't read it as the community control violation restarted the clock.
I think that maybe we're trying to distinguish between the two cases, Henderson and Hudkins, and the reason I think it's more in line with Henderson is because of the community control violation. Maybe I didn't make that clear, but I think that's what distinguishes Henderson from Hudkins. The other thing I would point out is we have to keep in mind that the defendant refused treatment, and that was part of the community control violation, and under Barker, that also
Where did
told
that,
us-
where was that information in the record, that he refused treatment?
It's on
didn't see-
page 42, volume 3.
Okay, because I didn't see that in the community control violation.
You know, it's odd because it says volumes 2 of 2, and then I got volume 3 of 3, and it's on page 42.
Okay,
And then it was brought up by the prosecutor, Ms. Adams, in this case, about prior case law that would toll, that doesn't count the treatment time because he, referring to Mr. Swanigan's, not compliant with treatment. So that's on volume 3 of the transcript.
Thank
on
you.
Page 42. So that's another factor to be taken into account. But again, I think it's more in line with Henderson because of the separate charge. I know it's the same case number, but we have new charges here.
So that kind of gets around, the defense made a very persuasive argument that if we are continually resetting every time somebody becomes competent, we could indefinitely
Yeah, that's not,
incarcerate them.
right.
Sounds like what you're saying is that for a community control violation, we reset with the 6 months, and we got 6 months to make this person competent, and if not, then it gets dismissed.
Then it gets dismissed, yes, yes. Otherwise, I agree with the defense, we would have an issue there,
A constitutional problem.
a constitutional problem of that recycling over and over again. And also, we can't forget also the defendant did refuse treatment. And I know that was just briefly mentioned, though, I mean, but it was brought up by Ms. Adams.
But why
It
is
was
that?
brought up
Why
by
is
Ms.
that?
Adams.
I'm trying to understand why you're.
There's a case, State versus Barker, and if a person refuses treatment, the time of restoration that they are being restored to treatment is told.
Okay.
And that's under State versus Barker. And Ms. Adams did bring that up on page, again, volume 3, page 42. So that's another aspect that I think favors what the trial court did, and we would ask this court to affirm the trial court for those reasons.
Okay.
Any questions? All right, thank you.
All right, thank you.
Thank you.
Ms. Pace, are you ready for rebuttal?
Just a few more minutes, Your Honor, or moments, Your Honor, if that's okay.
Okay.
Just like 10 seconds.
Okay. You have 5 minutes.
Just a few points in rebuttal, Your Honors. Firstly, Hudkins is the case that the court should be looking at to follow, not Henderson. This community control violation does not start the clock anew. This community control violation is a separate proceeding within the same charge, and the initial charge was that robbery. This community control violation, you have to take the case as a whole. You cannot separate it out, and so this is a separate proceeding within the same case.
So is that based on some statutory interpretation?
Correct.
So, like, if you remind me of the language in the statute, that would say that we can't consider the community control violation as starting the clock anew.
Simply, the language isn't there. And as this is statutory interpretation, you look at the plain, unambiguous language and there is no language that says, you know, the clock can restart if this is a community control violation. And since that language is not there, we do not imagine that into it. And so we read it as it says, which is that there is nothing that says the community control violation should be treated any differently. And with that, we ask the court to reverse and to dismiss the community control violation. Thank you.
All right, thank you. Thank you both for your arguments this morning. Nice job, Ms. Pace. The case is now submitted, and we will issue a timely decision. All right, thank you. Have a good rest of your day. The next case up is Diatech Financial LLC versus Balamunkwe. And this is a cross appeal, so I think you were all told that both sides can reserve rebuttal time. Mr. Parker, how much time would you like to reserve?
I would like to reserve 5 minutes.
5 minutes. And Mr. Moran?
3 minutes from you.
All right. I will do my best here. Okay. Whenever you're ready.
If it please the court, distinguished opposing counsel, I'm George Parker on behalf of Mr. Balamunkwe. Your Honors, this case has been remanded, was remanded in case C-180445 with specific instructions in the remand that were not followed by the trial court. I'll get to that after I discuss what I think might be the most important aspect of the appeal, and that's the fact that we probably shouldn't even be here. If the trial court would have followed the evidence, they would have come to the conclusion that, in fact, the plaintiff and the predecessor to the substitute plaintiff did not have standing to bring the initial complaint. They allege in their complaint at paragraph 1 that they were in possession of the note that they were attempting to foreclose upon. Yet the evidence that was presented belied that fact. The evidence was that Diatech was not in possession of the note and complaint. It was demonstrated in an email that was provided by NewRez that Diatech was asking its predecessor, where's the note? And then they indicate that the note was delivered to Diatech via FedEx 5 months after the complaint was filed.
Wasn't that delivered from the custodian?
That was the evidence that the NewRez presented that Diatech provided to them, showing that in fact Diatech hadn't had the note. So,
Well, wasn't Bank of America considered an agent? Was it Bank of America or New York Mellon? I don't remember. But wasn't that the entity that was holding that note? I thought there was evidence that.
Yes, the evidence was that Bank of America, that the Bank of America, New York
Mellon.
Yeah, that Bank of New York Mellon sent to Diatech, hey, where is the note? They weren't Diatech's agent. That's not what Diatech alleged. Diatech alleged in the first paragraph to their own complaint that they were in possession of the note. So under Schwartzall, we assert that the case should have ended at that point. That without standing, you can't assert the complaint.
Aren't there cases that have held that a mortgage assignee has standing to enforce the mortgage and foreclosure regardless of who holds the note?
I think that might be true, but the distinguishing factor in this case is that this note was endorsed in blank. And the only person that can enforce it is the holder of the note, which makes it distinguishable from the cases.
So that you're saying the judge's factual finding that they held the note was incorrect under the
Yes.
evidence?
Yes.
Okay.
Based upon the evidence that was presented from the initial plaintiff's records that were given to the subsequent.
Can you, while you're on the topic, respond to the waiver argument that they made, that the standing argument was waived?
I think it was actually raised in trial. And it
Yeah,
was-
but the argument is that it wasn't raised as an affirmative defense.
Oh, I thought
in
it
the answer.
was. According to the pleadings and according to the objections,
But was it raised in the answer?
I don't know.
Okay.
So I won't
I think
represent-
I'll let them argue. I thought that was their argument, that it was waived because it wasn't in the answer.
But I don't think standing can be waived, I don't think. I think that's jurisdictional. So jurisdiction can't be waived if you can't bring the lawsuit. Somebody can't consent to you bringing the lawsuit if you're not the proper party.
Well, I think it's an affirmative defense that can be waived. So,
Well, but regardless of not to belittle this argument, but the technicalities.
Yes, sir.
Is your client arguing that he never entered into an agreement with anyone for this mortgage?
Yes, and he's stated that and has asserted that throughout the case.
And does he have any reason to believe that the lender, or why the lender would pick him out of all the people that they could pick out to create this obligation that didn't exist otherwise?
We didn't really delve into the reason why he thought that. He just has always stated he did not sign that paperwork. And in fact, he went and asserted that, found an expert, had the expert present materials that overcame the motion for summary judgment, and then this court remanded the case to the trial court for a trial on those merits. And then at the trial, the court excluded that evidence as a result of saying, well, first of all, humbly, I don't believe that when you're set for trial that you can file at the late date beyond the local rule provisions a motion for a Daubert hearing.
Was there any objection below to the trial court or the magistrate holding that Daubert hearing?
I'm-
Like at the hearing?
I'm pretty sure that the council was saying, we should just combine this with trial. So that's why they,
since it was a bench trial.
yes.
For clarification, is your client also saying that the 2006 modification was forged?
Yeah, he didn't sign either document.
Okay. So it's the
So-
2004 mortgage and the 2006 modification?
And to be clear, it appeared as though that the remand, when you address what was the critical issue that we think that this court remanded it about was, just compare a signature on the 1999 document to a signature as alleged on the 2004 document. And that's what the trial court wouldn't do in this case. You know, we've got all kinds of cases to say, you really don't even need a handwriting expert. The trial court can make a determination of whether the signatures are similar. And you know what evidence that was never provided? By the plaintiff from anyone saying they witnessed him sign the documents.
I thought that one of them was notarized.
But there was never a witness to come in and say, well, yeah, both documents were notarized.
Right.
So
Isn't that enough that the signature was witnessed?
I think that might be the crux of the issue, is that the notary was never called upon. And isn't that to get to your point, Your Honor, isn't that really what the question is? We presume that a deed that's signed, that's notarized and recorded, that has validity. And I suspect that the plaintiff will say the same thing will happen with the mortgage. But if you look at the record, which you shouldn't have to do, but in the first appeal, that's what Mr. Balamanque was saying was, I never even knew about it. I was just sending my money into the same, because it ended up being the same processor. So he ended up sending his money into the same processor, and it was once he was faced with the fact that he had allegedly signed these new documents, he said, I didn't sign that. So, and I think that the remand, it seems to indicate under the Thayer-Wigmore bursting bubble theory of evidence, that once Mr. Balamunque has said and provided some evidence that he didn't sign the document, then it became incumbent upon the plaintiff to provide some counterbalancing evidence to show that, yes, that was his signature. Otherwise, how is one to disprove that they didn't sign something? His testimony, he was truthful and honorable and testified to it the whole time.
I think there was more information in the file, though, that convinced the judge that it was him, right? Because there were all these personal documents in the file.
Well, there were, and that might, I don't think he wanted to cast aspersions upon who may have benefited from having all that information, but the same group that initiated the first mortgage back in 1999, which is the same group that initiated the mortgage in 2004, already had those records in their possession. Okay. So, but then, and then in addition to that, the court did take into consideration that he had a divorce decree that required him to refinance his mortgage, and saying, well, he's just has a lapse of memory here.
I'm sorry if I'm confused on the
Yes.
facts, but your client was paying someone initially for this property, correct?
Well, he initially bought the property and had a bank finance the purchase of it.
And he was
Yes.
making monthly mortgage payments?
Yes, he was.
And did he at some point stop making those monthly payments?
He did once he realized that it was the wrong party who was suing him.
I'm sorry, he had already been sued? Did he
Yes.
stop making the payments
Yes.
before he was sued?
Yes. Well, or being threatened with foreclosure. That's why
Did he
that's-
stop making the payments before he was threatened with foreclosure?
I don't believe so. I think that's why he stopped, according to the record, as I understand it. He said, you can't make me pay, because it extended out the term and extended out actually even the amount, which is, I think that he got a deficiency notice. And so when he gets this deficiency notice, he's like, who is this asking me for this money?
So he was paying, but the deficiency notice indicated that he wasn't paying the new amount?
Yes, and
He was
enough, and it extended out the term. So there was, if I wasn't trial counsel, but if I would have been trial counsel, I would have asked, where'd the money go? And we know where the money went. And part of it went to the refinance.
No, I'm just confused. Did your client ever stop paying on this mortgage?
Yes. No, not this mortgage. He never, on his original mortgage, yes, he did.
He did stop paying?
Yes, sir.
Mr. Perry, you're over, you're
Thank
2
you.
minutes over your initial
Sorry.
time. You
Sorry.
still have 3 minutes for rebuttal, though.
Thank you. Thank you very
Okay.
much.
Good morning, Your Honors, and may it please the Court. My name is Jack Moran, and I'm here, as I said earlier, on behalf of NewRez LLC, which does business as Shell Point Mortgage Servicing, which is both the appellee and the cross-appellant in this case. Shell Point respectfully asks this Court to affirm the decision of the trial court's finding at the bench trial in Shell Point's favor for three main reasons. First, the testimony of Mr. Balamunque's proposed expert, Wendy Carlson, was correctly excluded at a properly convened Daubert hearing. Second, as the trial court determined, Shell Point had clear standing to bring its claims. And third, when the trial court considered those claims at the bench trial, it correctly found, as the federal court system had previously determined, that no forgery had occurred and that Mr. Balamunque had signed his home mortgage and the corresponding promissory note.
Can you start with the standing argument?
Sure. I'm flexible.
Okay, great.
A couple of things to note about the standing argument, because, Your Honor, you mentioned whether or not the defense was waived. I think one of
That
the
was
things...
your argument, right?
I'm sorry?
You all argue on appeal that it was waived.
I think we argue both that it was waived, and even if it had been preserved, we demonstrated standing at the trial court level. First, there is a case, State Ex Rel Jones v. Suster, that we cited from 1998 from the Ohio Supreme Court. To be candid with the panel, it is not a mortgage foreclosure case, so there's not a corresponding, reference to, say, the Schwartzwald decision. But in that Ohio Supreme Court case, it discusses standing in the context of an affirmative defense that needs to be pled. I would also note that Mr. Balamonkwe at the trial court level filed a number of different pleadings as a pro se litigant that don't conform to what we commonly expect in terms of pleadings, and one of them was a quote-unquote counter complaint that affirmatively stated that the mortgage and note was assigned to Ditech in 2016. So the record of the pleadings at the time that the first motion for summary judgment was filed in this case was that Ditech alleged that it was in possession of the note and the mortgage at the time it filed the complaint, and that Mr. Balamonkwe agreed with that in his responsive pleading.
So your argument, though, is that the standing should have been raised as an affirmative defense in an answer?
Correct.
Or an amendment or
Correct.
something?
Or in some of the pleadings
in
that
some of the
Mr.
pleadings.
Balamonkwe filed.
Okay.
Right. And if it had not been, even if it had not been raised formally in the pleadings, we would have expected that it would have been raised at some point more formally prior to essentially the eve of trial when this defense started to foment and it became clear that plaintiff was ready and able to challenge the admissibility and the reliability of Wendy Carlson's testimony. As that standing defense was brought up at trial, the appellee, Nurez, the plaintiff at the trial court level, introduced testimony from a records custodian of Nurez, which incorporated the documents from Ditech's file, which demonstrated that this note and mortgage, the note, I should be clear, the note, as was already acknowledged by this panel in the questioning of Mr. Parker, was held by a custodian. And there is an Ohio Appellate District Court decision that supports the concept that one can demonstrate constructive possession of a note. And so we would say that it's Bank of New York had constructive possession of the note when it was held by Residential Credit Solutions, that Bank of New York remained the custodian when that note was assigned to Ditech. There is no testimony to rebut that. There is testimony in the trial court record that affirms that. The trial court believed that testimony, which demonstrates that the note was possessed by the plaintiff at the time the complaint was filed. That means that there was standing. There was also, by the way, record evidence that there was an assignment of the mortgage that was recorded on July 8th, 2016, well in advance of the filing of the complaint. So both the note and the mortgage were possessed by Ditech at the time the complaint was filed. As was alluded to during the questioning of Mr. Parker, really the crux of Mr. Balamonkwe's odyssey of litigation on this is that there was a forgery. And that journey has taken him up into the federal court system, on appeal to this court now twice. And really, we believe that that journey now needs to come to an end. Focusing on the original appeal and not our cross appeal, Mr. Balamonkwe can't demonstrate, first and foremost, any abuse of discretion in convening a hearing on the plaintiff's Daubert challenge. First and foremost, the local rule that the appellant is citing to simply does not apply to this. That's a local rule that relates to oral arguments for motion practice. This is an oral argument. This is not a Daubert hearing. There's no witness chair here. This is not a trial court. This is the local rule 14C at the Hamilton County Court of Common Pleas does not apply to Daubert hearings. Even if it did, as Your Honor, Judge Bach acknowledged, it was waived. There was not any objection to convening this hearing. There was nothing in the record that did that.
And please refresh my memory. Was there an objection to the magistrate's decision based on the magistrate holding a Daubert hearing?
I don't believe so, Your Honor.
Okay.
I suppose that's another good argument for why this argument was not preserved. There was a number of different objections to the magistrate's decision that were lodged by Mr. Balamonkwe, but the actual formal convening of the hearing was not one of them.
Thank you.
Mr. Balamonkwe, for what it's worth, was represented by competent counsel at that hearing and engaged fully. There's a little bit of confusion on the briefs. Mr. Balamunkwe's brief says that the hearing occurred on the same day as the trial. It's not quite accurate. It occurred the day before the trial. But the hearing was fulsome. It was thorough. I don't think that hearing could have happened on the same day as the bench trial because we would have gone into the next day. And the trial court's review of Ms. Carlson's qualifications was also not barred by the law of the case. I want to be careful here. I don't want to presume to tell Judge Krause what the mandate was on Balamunkwe 1, because you were there and I wasn't. But from reading the decision, it appeared to me to be pretty simple. The decision was that the trial court had failed to acknowledge the existence of Ms. Carlson, her affidavit and her report, when granting a summary judgment order that, for the sake of the court's, to refresh the court's recollection, the first summary judgment grant in this case was sort of a boilerplate, by the book, summary judgment grant of a residential foreclosure case. There wasn't any acknowledgement of this filing by Mr. Balamunkwe.
And there was never a challenge below in that case to her qualifications.
There was not a challenge below to her qualifications at that point. Instead, DITEC's counsel, because DITEC was the plaintiff at that time, moved for summary judgment by basically saying, we have standing, we have the note, we have the mortgage, there's been a default.
There's no issue, no material issue of fact.
Correct. Yeah. So obviously, if the trial court doesn't consider the existence of a proffered expert on an issue of fact in the case, then summary judgment is understandably reversed. But that reversal doesn't necessarily mean that the expert, who wasn't acknowledged initially, is now magically qualified to testify at trial. Those are two completely different legal determinations, the second of which was not addressed by this court in Balamunkwe 1. So there's no mandate from the appellate court that barred the trial court convening a Daubert hearing. Mr. Balamunkwe asserts what I believe is the common refrain of the party that lost at a Daubert hearing, which is that the testimony evidence introduced at that hearing should have gone to the weight of Ms. Carlson's testimony, not to its admissibility. But this is an issue that is relatively novel for me. I don't know if it's novel for this panel, which is a Daubert hearing and a bench trial. I'm not really sure what Mr. Balamunkwe's point is. If the trial court did not find Wendy Carlson reliable enough to even admit her testimony, then it's not clear to me how Mr. Balamunkwe can argue with a straight face that had that testimony been admitted the next day at the trial court level, it would have changed the outcome. We do believe that it was properly excluded, as under Rule 702, there was some obvious defects with Ms. Carlson's methodology.
And we review that on an abuse of discretion basis, correct?
Correct.
Okay.
Yes.
So even if one of us would have said, yeah, that evidence comes in, that doesn't really matter here. It's just whether the trial court's decision was arbitrary, unreasonable, or unconscionable.
Yeah, and I don't think there's much to demonstrate. Yes, Your Honor, I agree with what you're saying, Judge Bach. And also, I mean, I think that there is no real demonstration here as to how the trial court abused its discretion. I think that Mr. Balamunkwe doesn't agree with the outcome, but where the trial court was arbitrary in its distinction, I don't see it in the record, and I don't really see it in the briefs. That same abuse of discretion standard applies to the underlying forgery claim. There is a lot of discussion I could engage in about magnifying things by 200% and copies of copies, but I think, really the most important thing, the most important legal principle on this issue is actually Mr. Balamunkwe's brief and not in ours, which is that the trier of fact has the right to make a determination as to the authenticity of a signature. We agree. The trial court had the right to evaluate the authenticity of a signature. It did that. It considered the W-2, the pay stubs, the tax returns, the driver's license, all of the other records that were in the file from 2004. It considered the fact that Mr. Balamunkwe had not introduced any testimony from the notary. I mean, this panel was asking questions about the notary. I actually believe that something that Mr. Parker said I disagree with, which is that the party claiming forgery over particularly a notarized document has the burden of proof. Mr. Balamunkwe is not permitted to appear in court, say, I didn't sign this thing that is notarized and recorded, and then shift the burden completely back to the plaintiff to prove that he was there, 20 years earlier, and was the one that signed it. I believe it's incumbent on Mr. Balamunkwe to prove that.
So one of the One of the issues raised by your opponent was that the magistrate did not look at or compare the signatures. Is that borne out in the record?
I don't believe that there's any particular part of the record. I think the more specific argument that Mr. Parker is making is that the magistrate did not compare the 1999 signature to the 2004 signature. I don't see anywhere in the record or in the briefs where the magistrate or the trial judge explicitly say, I refuse to look at the 1999 signature and I won't compare it to it. And so I don't believe there's any record support for the argument that the magistrate refused to compare it.
But there's no support that he did, I mean, we don't know what he did.
What the magistrate did is evaluated all the evidence at that bench trial and made a finding that Mr. Balamunkwe signed this note and mortgage, and thus judgment was rendered in favor of the plaintiff. That's evaluated under abuse of discretion standard. I don't see any abuse of that discretion in the record. I'd like to briefly mention, I know I have to wrap up.
You're at your initial time if you want to eat into your rebuttal time.
No, that's okay. I'll reserve the rest for rebuttal. Thank
Okay,
you, Your
you
Honor.
have 3 minutes for rebuttal. And Mr. Parker, you also have 3 minutes.
Thank you. The abuse of discretion occurred when the magistrate refused to allow Wendy Carlson to testify, because part of what Wendy Carlson's report, an expert report that was used to overcome the motion for summary judgment on appeal, was that the signature from 1999 did not match with the signature from 2004. Another issue that on their cross appeal, and he didn't cover it, but I have my 3 minutes, so I want to address it. My question, I think to say that the court made an error by not granting their motion for summary judgment, then you have to ask the question, how many times can you file for summary judgment? The predecessor, Ditech, filed for summary judgment, and that was reversed and remanded. So I think that they had their bite at the apple. They don't get 2 chances to file for summary judgment.
Yeah, what authority are you basing that on?
I have I have
Fairness.
none other than the fact that that if you move for summary, it doesn't, Rule 56 doesn't say you can file for summary judgments. I guess you could have on an issue that wasn't addressed, but it just appears as though that's.
They knew about the federal case at the time of the first filing. So I hear what you're saying. I couldn't find any authority that says they couldn't.
Yeah, that's why I left it for the short 3 minutes that I had in rebuttal. We would ask the court to remand the matter to the trial court for the sole purpose of allowing Wendy, well, for a dual purpose. First, to have Wendy Carlson be able to testify as to why the signature on the 2004 document wasn't correct. I think the analysis disregarded that specific portion of the rule. The magistrate says she's an expert, but she's not expert at this.
Well, he said that he had issues with her application of her methodology. And so my question to you is, in a bench trial situation, this is not a jury trial, is the same trier of fact is going to have to listen to her testimony. And if the trier of fact doesn't think that her methodology is right, he's not going to believe it.
Yeah, I think that's almost analogous to the Court of Appeals reversing the trial court's decision to grant a motion to suppress evidence, and then send it back to the same judge who's going to hear the same thing. He's going to come to the same conclusion. So I think that the specific remand required there to be a more thorough analysis of the fact that Mr. Balamunkwe had established that it wasn't his signature for the purpose of overcoming summary judgment.
Oh, wait. I don't think that's what the panel in that case held. Instead, it held that Ditech was not entitled to summary judgment because there were genuine issues of material fact. The court did not hold that the signatures were forged. It didn't hold that Ms. Carlson was qualified or that the court had to accept her testimony. This was just a summary judgment motion, and the court found that the report established a genuine issue of material fact. Not that one side was going to win, the other side was going to lose.
Right, and so that the genuine issue of material fact was that they need to come to the conclusion of whether or not the signature was a forgery or not. And I still think that comparing the signature from the 1999 document to 2004 should have been a finding or should have been discussed in the determination of all the things that were considered, because as the court had mentioned earlier, they did have those records, but that was part of the records they could have had from the previous loan. Thank you.
Thank you very
much.
much.
Thank you.
You have your 3 minutes.
Thank you, Your Honor. Just a few things on rebuttal. First, I'd like to address the pure rebuttal point that Mr. Parker just made, which is that the abuse of discretion lied in the trial court's refusal to consider the 1999 signature on the note with the 2004 signature on the note. What I heard Mr. Parker to say was that that abuse of discretion was back to the exclusion of Ms. Carlson's report. The exclusion of, and Ms. Carlson, of course, compared the 1999 signature with the 2004 signature. I don't know that it's true, and in fact, I would submit that it's certainly not true, that just because the Carlson report is excluded, the trial court is necessarily not conducting the same analysis that is discussed in the Carlson report. So just because Wendy Carlson's expert report or expert testimony was excluded at trial does not foreclose the trial court from considering the signatures that were put into the record. Those signatures were put into the record. The trial court was the trier of fact. It had the ability to compare signatures if it wanted to and hear all of the other testimony that was submitted over a long bench trial and found that Mr. Balamonkwe signed this note and mortgage. That is a decent segue to our cross appeal, which is that the federal district court and the Sixth Circuit Court of Appeals also found years earlier that Mr. Balamonkwe signed this note and mortgage and that there was no issue of fact on that point. I want to just briefly acknowledge, for the sake of the panel, that this wasn't argued in the first summary judgment motion, and so we have an interesting tension here. The appellee is accusing the appellant of not being a good use of judicial resources, and the appellant is accusing the appellee of the same thing. What I would say is that the first motion for summary judgment raised the fundamental issues in any mortgage foreclosure, and the briefing on that was, it was granted by the trial court magistrate. This court determined that it was an error. When it was sent back, new counsel represented the plaintiff at that point, discovered the issue, and raised it. There is nothing in Civil Rule 56 or in this court's jurisprudence that prohibits us from doing that.
So the trial court refused to consider your argument because it was, the trial court thought you should have filed it earlier, right?
The trial court made a ruling that I still don't entirely understand here, whether it's a law of the case argument or that it should have been filed earlier. I think what I didn't see is the trial court issue a decision at some point that says all summary judgment motion briefing needs to be filed by this date, otherwise we won't consider it.
If the trial court, if one of the grounds for rejecting your summary judgment motion was that you didn't file it earlier, it was too late, the timeliness, would we be reviewing that on an abuse of discretion?
I believe that's correct, yes.
Okay, so we would say if that's what they did, then on the merits would be a de novo.
Correct.
Okay.
Yes. Yeah. And just to harken back to that point, I think that in this instance, the trial court did not communicate to the parties either before or after the summary judgment motion was filed that there was some date certain and the case management dates or elsewhere that foreclosed our client's ability to file a motion for summary judgment. We think the motion was properly supported. That's laid out in the briefs. And as a result, we felt like summary judgment should have been granted. So I see my time is up. For the reasons explained in our brief and as discussed here today, we respectfully ask that this court affirm the trial court's decision at the bench trial or, in the alternative, reverse the trial court's denial of their second summary judgment motion. Thank you.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted and we will issue a timely decision. And that concludes court for today. Thank you all.